Hello and welcome. I am Dr. Manvendra Kumar Tiwari, and I am an associate professor at the Dharmshastra National Law University, Jabalpur. Today, continuing our discourse forward in the legal reasoning part, we will discuss in constitutional law recent development part 2. In first part, we discussed a judgment that was based on the interpretation of the term material resources as it appears in Article 39B and 39B forms part of Article 31 capital C. So the 9-judge bench on 5th November 2024 interpreted that term, and we discussed that judgment in our first constitutional law recent development portion. In today's discussion, we will have a discussion on bulldozer injustice. I call it bulldozer injustice and not bulldozer justice. Now, this is based on a recent judgment delivered by the Supreme Court of India on 13th November 2024. And this relates to the instances of the use of bulldozer by some of the municipality authorities against the people who have been accused in a criminal case. Now, the problem is because the persons whose houses were so demolished by the municipal authorities, the reason for the demolition given has always been the violation of the municipal laws. Yet the portrayal in the media has always been that this is a punishment that has been given to the person on account of his involvement in a criminal case. And that's why this was a peculiar situation where the courts were not pronouncing the punishment. Courts were not even pronouncing their judgment on the determination of guilt. Rather, there is a parallel criminal case that is ongoing against the person, and yet the municipal authorities would suddenly woke up and demolish the house of that person accused, citing violations of municipal laws. And so the municipal action in law will be suggested as if it is completely dissociated with the criminal case against the person whose house has been demolished by the municipal authorities. Yet the popular understanding and the popular portrayal in the media has always been that this is a punishment that the government has inflicted upon the person for his alleged involvement in the criminal act. And that's why this was disturbing on so many reasons. And this continued for a considerable period of time. And recently, only on 13th November 2024, there were petitions filed against these actions of the municipal authorities, but the matter remained pending with the Supreme Court. And only on 13th November 2024, the Supreme Court has delivered its verdict in re directions in the matter of demolition of structures. This is the name of the judgment. Now, this is a passage that I've taken from the blog piece by Gautam Bhatia on his blog, The Indian Constitutional Law and Philosophy, and it reads, on 13th November 2024, the Supreme Court delivered its judgment along with a set of guidelines. So the judgment also contains guidelines for the municipal authorities to adhere before they decide to demolish a structure. So along with a set of guidelines in the case of in re directions in the matter of demolition of structures, I must note at the outset that within the constraints of the guidelines route, the court did frame a very strong set of directions which, if enforced in the future, should make it far more difficult for the state authorities to engage in punitive demolitions. Late is the hour in which these guidelines chose to appear, but better late than never. A few points about the judgment, which runs into 95 pages. The fundamental question that the court frames is whether the properties of the persons who are accused of committing certain crimes, or for that matter, even convicted for commission of criminal offences, can be demolished without following the due process of law or not. The court then spends the next 60 pages going through the concepts of the rule of law, the separation of powers, the rights of the accused, the right to shelter, and collective punishment to answer as follows, which is no. It was rather obvious that no action can actually be undertaken without following the due process of law, and that's why the answer was inevitable. One appreciates the effort and the painstaking recounting of precedent on each of these points, but it does give the judgment a somewhat surrealistic flavor because nobody at any point ever advanced the legal claim that the answer was yes. The whole point of Bulldozer Raj was, we have discussed multiple times on this blog, this is Indian Constitutional Law and Philosophy blog, is that it allows the state to speak with a forked tongue. Politicians dog whistle to their base by talking about vengeance and collective punishment, while the municipal authorities, the ones actually legally responsible for demolitions, cite municipal laws and unauthorized constructions as justification. The other problem with this framing is that the court repeatedly refers to arbitrary executive action in demolishing house. But that is the whole point. That is the whole point. Bulldozer Raj is not and has never been arbitrary. It is the complete opposite. It has been the targeted and punitive. There is a very important moment in the judgment where this understanding bleeds through. In paragraph 82, the court notes, when a particular structure is chosen all of a sudden for demolition, and the rest of the similarly situated structures in the same vicinity are not even touched, malafide may loom large. In such cases where the authorities indulge into arbitrary pick and choose of the structures, and it's established that soon before the initiation of such an action, an occupant of the structure was found to be involved in a criminal case, a presumption could be drawn that the real motive for such demolition proceedings was not the illegal structure but an action of penalizing the accused without even trying him before the court of law. That's a very pertinent observation. Here, at last, we have the recognition that what has been going on is not arbitrary pick and choose, but malafide state action. This observation is, of course, hugely important as it will assist future litigation against punitive demolitions, and it suggests that the court is indeed aware of what has been really happening, but that it believes that the best way of addressing the issue is in an indirect way. We then come at last to the actual bite of the judgment, which is the guidelines themselves. Here I believe that the court deserves appreciation. It is in the guidelines that we find most clearly, as noted above, that the court is both aware of the true situation and is determined to do something about it. Even though it chose not to name the situation in its judgment, the entire tenor of the guidelines is to interpose certain specific elements of due process that will make it much more difficult to extract political mileage from demolitions. Important guidelines include a minimum 15-day notice period, regardless of what the municipal law says, the right to a hearing, the obligation to supply written reasons for demolition, the right to an appellate procedure, and the verifiability to prevent backdating. Once again, the court's specific mention of backdating shows that it is aware of the methods used by the authorities to circumvent due process requirements. This backdating is that though the demolition used to be sudden, but the municipal authorities used to always come up with documents showing that the notice to this effect was actually issued days before, and that the decision to demolish has not been taken instantly. But this was generally done by backdating the documents to show that the show cause notice was in fact served to the persons whose houses were to be demolished. And that's why the court shows its awareness of these tactics. If these guidelines are enforced, than instant demolitions that are sold politically as a form of state-sponsored vigilante justice outside the constraints of the slow-moving legal machinery will become impossible. And once instant demolitions become impossible, one may hope that the entire incentive for such demolitions will go away. Another important and praiseworthy point is on substance. The court is on substance. The court explicitly incorporates the doctrine of proportionality into the calculus of reasons that the municipal authorities must provide. In particular, the municipal authority must record a finding that no less restrictive method other than demolitions is possible, and must also explain why other options, such as regularization or compounding, are not possible. This is the doctrine of proportionality, exactly how it should be applied. That is, requiring the state to publicly explain its decision-making process when it infringes people's rights. If this too is enforced, then once again there is a strong hope that the bulldozer Raj will be a thing of the past. And finally, there is the court's crucial holding that in cases of non-compliance, the responsible public officials will be personally liable for a wrongful demolition. This has been a long-standing necessity, as it is immunity that begets impunity. The removal of immunity, thus, is an important first step in tackling impunity. All in all, then, through its guidelines, the court has undertaken a comprehensive attempt to put an end to bulldozer Raj. The efficacy of these guidelines will now depend on the future cases and the will and the ability of future benches of the court to enforce them. But for today, the importance of this judgment cannot be understated. Now, we'll see a few questions based on this paragraph. In re directions in the matter of demolition of structures, the judgment was delivered along with guidelines, orders, injunctions. Guidelines. Option A. The fundamental question that the court framed to inquire in this case was whether the properties of the persons accused or convicted of some crime can be demolished without the due process of law. Option B. The Supreme Court states in its judgment that executive actions were arbitrary, but the author says that the actions were punitive and targeted. C. Option C. The court answered the question framed by saying no, but it was nobody's argument to say yes, that we saw it. Whether such demolitions can actually take place without following the due process of law, the court's answer was no, but nobody argued that that demolitions are actually possible without following the due process of law, and that's why it was nobody's argument to say yes. Fifth question, when a particular structure is chosen all of a sudden for demolition and the rest of the similarly situated structures in the same vicinity are not even being touched, what may loom large? Bona fide, malafide? Malafide, clearly. Option B is the right answer. But we also have bad faith. Malafide is what bad faith means. So it's a slightly tricky option. So option D, both B and C will be the correct response. Malafide and bad faith. Sixth question, where the authorities indulge into arbitrary pick and choose of the structures and it is established that soon before initiation of such an action, an occupant of the structure was found to be involved in a criminal case, an adverse presumption may be drawn against the authorities. Yes, no presumption, wrong. Conclusive proof, no. An adverse presumption may be drawn against the authorities. So option B is the right answer. The Supreme Court is indeed aware of what has been really happening, but that it believes that the best way of addressing the issue is in an indirect way, without actually discussing the politics of this demolition. It chose to address the question in an indirect way, entirely through the legal lens, and that's why indirect, option B, is the right answer. The entire tenor of the guidelines is to interpose certain specific elements of due process of law, making due process compliant. These demolitions is what the purpose is. So therefore, option C is the right answer. If these guidelines are enforced, then instant demolitions will come to an end that are sold politically as a form of state-sponsored vigilante justice. This is street justice. That's what vigilante justice is, that you don't follow a procedure that will happen in the court in order to come at a punishment. You have devised your own means of giving punishment. And that's what vigilante justice means. Option C is the right answer. The court's crucial holding that in cases of non-compliance, the responsible public officials will be personally liable. So option B is the right answer. So that is it so far as the recent development about the bulldozer injustice judgment of the Supreme Court is concerned. Thank you very much.